Good morning, everybody. My name is Peter Letzu, and I have the privilege of serving as Dean of the most beautiful and inspiring law school in America, the Cecil C. Humphreys School of Law at the University of Memphis. And it's my pleasure to welcome all of you to our 2014 University of Memphis Law Review Symposium, this year entitled Juvenile Courts in Transition, Where We Have Been and Where We Are Going. As I expect most of you in this room already know, the Juvenile Court of Memphis and Shelby County reached a landmark agreement with the United States Department of Justice in December of 2012, after nearly 3-year investigation by the Department of Justice. And today's symposium will explore the transition of the Juvenile Court of Memphis and Shelby County, as well as explore new directions in juvenile justice. The symposium will analyze juvenile courts in transition from multiple perspectives. We'll have speakers from the Department of Justice, the Juvenile Court of Memphis and Shelby County, along with juvenile justice scholars and practitioners from a variety of organizations from throughout the nation. Our program will also analyze timely topics in juvenile justice involving special education for juvenile detainees, confidentiality in juvenile proceedings, and advocacies for juvenile clients. We're delighted to host an exceptional group of speakers whom I'll introduce now, and I'll ask our speakers maybe to stand as I introduce them, and I'll be doing so in the order in which they will be speaking today. Our first speaker will be Winsome Gayle. She is Special Litigation Counsel with the Juvenile Rights Division of the U.S. Department of Justice. Next is Sandra Simpkins. Sandra is Clinical Professor and Chair for Clinical Programs at Rutgers School of Law and the Department of Justice Monitor for the Juvenile Court of Memphis and Shelby County. Stephen Bush, right in the front. Stephen is Chief Defender with the Shelby County Public Defender's Office. Tom Coupe. Tom is Supervising Attorney and Coordinator for the Judges Action Center at the Juvenile Court of Memphis and Shelby County. May Quinn. May. There to my side. May Quinn is co-director for the Civil Justice Clinic at Washington University School of Law in St. Louis. William Wesley Patton, in the back, is a lecturer in the Department of Psychiatry at the UCLA David Geffen School of Medicine and professor, and J. Allen Cook and Mary Shalling Cook Children's Law Scholar at Whittier Law School. Lisa Geis. Lisa is clinical instructor in the Juvenile and Special Education Law Clinic at the University of the District of Columbia, David A. Clark School of Law. Arthur Horn, here in court, but will be here later in the program. He's a civil litigator with Horn and Wells here in Memphis. Magistrate Dan Michael, he will be here with us later today. Chief Magistrate with the Juvenile Court of Memphis and Shelby County. And finally, Julian Adler, who I know is here in the front, is the director of the Red Hook Community Justice Center in Brooklyn, New York, a demonstration project of the Center for Court Innovation, also located in New York. Thank you to all of our speakers for being here today. Unfortunately, one speaker could not be here with us today, and that is Mr. Alfred Siegel. On January 16, 2014, Mr. Siegel, Deputy Director for the Center for Court Innovation in New York, passed away at the young age of 62. Over his long career, from his years as Assistant District Attorney in the Bronx to his tenure as Deputy Commissioner of New York City's Department of Probation, to his work with the Task Force on Transforming New York's State Juvenile Justice System, to his 15 years at the Center for Court Innovation, Mr. Siegel worked tirelessly in the justice field. The Cecil C. Humphreys School of Law mourns Mr. Siegel's untimely passing and would like to recognize him and honor his legacy in the field of juvenile justice. So, thank you for taking time out of your busy schedules to be with us today. The University of Memphis Law Review, under the very capable leadership of Editor-in-Chief Kyle Cummings and Symposium Editor Sandra Newcomb, has done an outstanding job organizing this event, as our speakers already know and as our audience will see throughout the day. So please join me in thanking them for all their hard work And once again, welcome to all of you. So thank you to our organizers. And with that, I give you Kyle Cummins, who's the editor-in-chief of our law review, who will take the program from here. So thanks again for being with us. Thanks, Kyle.
Good morning, everyone, and welcome. We're glad to have you all here. The dean has welcomed you on behalf of the law school, but I just want to personally welcome you on behalf of the University of Memphis Law Review. This is something that we look forward to every year, and we're so glad to have all y'all here. I know there's more that are going to be trickling in. It's a joy to see so much work come to fruition. I just want to give a brief history of, not a history. I'm going to give you some remarks on the symposium and what we've done in the past. So each year we have a symposium, as many other law reviews do. We try to bring in experts in a particular field of law who can discuss the issues related to that field of law. Last year we hosted a discussion of legal topics in human trafficking, and the year before that we hosted a discussion of cultural competency and the death penalty, and had a few members of the West Memphis, or a member of the West Memphis 3, and some discussion of that. As you all know, these issues are interesting for us as law students, as practitioners, as judges, and as academia. But if you're a native Memphian like me, like many of us, these issues hit close to home. And so it's a joy to see topics like this discussed here in our community and potentially be a blueprint for those outside of our community. Today's topic furthers those same goals. This is a topic of nationwide interest with deep roots in the city of Memphis. Along with this symposium, we dedicated an entire issue of our law review, the last book of Volume 44, to the topic at hand. And so I've had the joy and privilege of working with some of our speakers and a few others who are also authors for Book 4 of our symposium, which will be available by the beginning of the summer in print. Spent a considerable amount of time reading and editing those pieces, which has been wonderful. I admit that I'm a novice on the subject, but after reading the pieces, have just become impressed with the central importance of this issue, not only here, but in our country as a whole. And so I'm proud that Memphis has an opportunity here to kind of be a blueprint and to be a forerunner in this area and to move forward. Before I hand this off to our first introducer, I want to thank two people just very quickly. First is Professor Andrew McClurg. Would you raise your hand, Professor? Professor McClurg is the faculty advisor for the Law Review, and he has been a tireless advocate for us the entire year. He helped put this together, and he has provided guidance, his time meeting with me, meeting with Sandy, and he is constantly available, which is something that I value and that we value as a Law Review. And second, most importantly, sorry, Professor McClurg, this one is most importantly, but I do want to publicly acknowledge Sandy Newcomb, our symposium editor. Sandy spent countless hours putting this together. The logistics involved are tremendous, and she handled it with grace. And she came up with the topic last spring, brought it to the Ed Board's attention. We solidified the topic. She solicited speakers, solicited authors, dealt with an amazing amount of logistics, and she has done it well, and we are excited to see her finished product, Sandy. So if everyone would, please thank Sandy. So with that, welcome on behalf of the University of Memphis Law Review. We are, if you have any questions throughout the day, please feel free to contact me or any of the spruce-looking folks in the top left who are also members of our Law Review. Anyway, with that, I will hand this off to our first introducer, the incoming managing editor of the University of Memphis Law Review, Logan Klaus.
Hey, folks. My name is Logan Klaus, and I am the managing editor for Volume 45, which is next year's University of Memphis Law Review. Let me be the third of what will likely be 25 more people to say thank you for coming and welcome to this year's symposium. It is my distinct privilege and honor to introduce our first speaker today, Ms. Winsome G. Gayle. Since graduating from Harvard Law School, Ms. Gayle has been a zealous advocate for juvenile justice. She's worked with the firm Debevoise and Plimpton, where she led a pro bono investigation into Sixth Amendment violations in the Louisiana juvenile public defender system. She also worked with the District of Columbia Public Defender Service, representing juveniles and adults before the D.C. Circuit Court of Appeals. Ms. Gayle later joined the U.S. Department of Justice Civil Rights Division, where she continued her juvenile advocacy, leading an investigation into the Dozier Juvenile Facility, which is located in Marianna, Florida, but not anymore because her investigation ultimately led to the closure of that facility. She also led an effort here in Memphis that Dean Letsu referenced in his introduction, where Ms. Gayle pursued due process and equal protection rights for juveniles here in Memphis, and ultimately she was able to effectuate reforms in that she created, or was part of creating, the Juvenile Public Defender Service here in Memphis, and she established alternatives to incarceration, which is great for our city. Ms. Gayle currently serves as Special Litigation Counsel for the Juvenile Rights in the Special Litigation Section for the Department of Justice. And in her capacity there, she is responsible for the enforcement of juvenile justice provisions of 42 U.S.C. Section 14141, and has focused her investigations on systemic unlawful practices in juvenile justice. And, as I learned last night, she is a vegetarian and a huge fan of mac and cheese, which kind of derails the introduction, but hey, you win some, you lose some. Here to discuss protecting the rights of juveniles through enforcement of Section 14141, please join me in welcoming Ms. Winsome G. Gayle.
You got away with that mac and cheese reference, but I do love it, and baked, not baked, whatever way, as long as you don't put bacon in it, which is something that people in DC are really starting to do a lot of. I hope that does not spread to Memphis, because then I would be in trouble. So I'm going to try to be as brief as possible, because a lot of what I'm going to say is going to be fleshed out more later on today. I want to take you all back to 1964. And some of you already know what I'm going to talk about. So in 1964, a little kid by the name of Gerald Galt, who kind of was a troublemaker. He was kind of like a Dennis the Menace. Allegedly, possibly, with one of his friends, decided to engage in a crank telephone call to his next-door neighbor. Well, his next-door neighbor wasn't too happy about this, and lo and behold, the sheriff comes and arrests Gerald, and he gets adjudicated delinquent, and he's committed to a juvenile facility, in essence. In May 1967, almost 3 years after Gerald's prank, the Supreme Court reversed that decision. Gerald was subject to detention for 3 years for an offense that, if he were an adult, he would have gotten $5 to $50 fine or 2 months maximum in a facility. Gerald had no attorney. He had no idea that he even needed an attorney. He received no notice of the charges except that he was being suspected of being a delinquent. And he was forced to provide incriminating testimony against himself, all because he was an adolescent without the protections afforded under the Constitution at that time. Well, the Supreme Court changed the course of juvenile courts with the Galt decision when it stated that a condition of being a boy does not justify a kangaroo court. Since that decision in 1967, the last 4 decades have been marked by our national efforts to rid the juvenile court of the paternalism that under which it started. In cases like Galt, cases like Kent, which came about the year before Galt. And recently, the Supreme Court has, in essence, declared that juveniles are different than adults in cases like Miller, Graham, and Roper. And those decisions basically embrace scientific proof of what we all know. Kids are different. Adolescents do make stupid mistakes. They have great thoughts, but no control over themselves sometimes. And this makes the need for protections when they come before the juvenile court even greater. And yet, I'm sure you're all familiar with juvenile justice systems that are quite simply broken. Systems that do not respect the due process rights of children, that treat them differently based upon their race, based upon their gender or their ethnicity, and systems that subject children to the type of kangaroo court processes that the Supreme Court found problematic decades ago. In the Civil Rights Division, we've been given the responsibility of addressing these problems under what's called, it's a mouthful, the Violent Crime Control and Law Enforcement Act of 1994, Section 14141. And a lot of people are familiar with that statute because it's the local name for it is the Rodney King statute. It's the statute that came about after that incident to investigate wide-scale police abuse as opposed to indicting single officers. Well, that statute has an administration of juvenile justice component. And in the last, I would say about 5 years, we've started to provide some teeth to that juvenile justice component. And yes, we started in Shelby, but we didn't stop there. We went on to Meridian, Mississippi, and now we have another public investigation in St. Louis, Missouri. There are other investigations that are going up, but they're not public yet. What are we doing? So we're aiming to address these long-standing problems that to some people seem intractable, but what they require is a commitment by the leaders of juvenile courts to embrace what the Supreme Court found in Galt. And one of the most important part of this is respecting the role of defense counsel as advocates for children. Our hope is that our reform efforts here will inspire changes in other jurisdictions. However, if the lessons learned here are not heeded, unfortunately, we'll have to keep opening up investigations and in some cases engaging in litigation, which is what's going on in Meridian, Mississippi. So I'm just going to do a very brief summary of what we found in Shelby, because you are all probably more familiar with it now than I am, because we've been here a lot and I've talked a lot. So let me be brief. We publicly announced our investigation 2 years after we started our preliminary investigation, so in 2009. And some of the allegations that we heard were similar to allegations from Galt, including basically detention, charging a child without really providing them with notice of why they were being charged. We found some additional things that the court had a problem with in Kent, transferring children to adult court without really providing their attorneys with the chance to hold hearings or request hearings and then hold the hearings before transferring the child to the adult court. Conduct that resulted in self-incrimination. And we also found a disparity in the treatment of children based on their race, working with a statistician. Before I talk about some of the solutions in Shelby, and there are a lot, and Shelby has been doing really spectacular work and been an inspiration to, I hope, to other jurisdictions. I just want to give you a little bit of background about our other two public cases. In Meridian, which is in Lauderdale County, Mississippi, this is a traditional school-to-prison pipeline case. Students who are mostly black students and students with disabilities are basically being removed from their schools by law enforcement without regards for their rights, probable cause. A lot of the removals are the result of probation violations based on school disciplinary infractions. And that's a whole lot of way to tell you nothing really. I'm going to describe one of the school infractions. Uniform violation, where a child wears a uniform, wears a blue polo shirt that is a little bit off color because it's been washed so many times because the child does not have money to buy new polo shirts. So it's a little bit off color from the regular uniform. That has landed a child in Meridian, Mississippi in the juvenile detention. So there we are also finding that the judges are not engaging in the probable cause inquiry that they need to engage in before the children are detained. And as I mentioned before, it's now being litigated. There was a motion to dismiss on abstention charges. The federal judge kicked that and said, no, there is no abstention. I'm not going to abstain. This is the case that's rightly before me. And now it's in discovery. Unfortunately, it might take years for them to finally get to the point where Shelby is in trying to reform the system. In St. Louis, we're looking at some of the same issues in St. Louis, and because it's so new, I can't really tell you much, except that if you want to find out more than what we have said publicly in press releases and what have you, you should check out the NJDC National Juvenile Defender Center's report on what's going on in Missouri. And it's basically a crisis of public defense services in that state. And we're trying to assess whether or not the limited resources to juvenile defenders in the state is impacting the children's due process rights. And there's also allegations that we're investigating related to racial discrimination there as well. So back to Shelby. So our agreement has been in effect since December 2012 now, as you heard. And I must say that before we inked the agreement, before we announced it, the juvenile court started taking steps, and the county started taking steps, including assigning Mr. Bill Powell. Bill, are you speaking today? You're not speaking, right? Bill really should be speaking, but that's okay. He's shy. But assigning Mr. Bill Powell as basically a compliance coordinator to work with the court to try to solve some of these issues that they're trying to address. So that started well before we inked the deal, and I think that showed that the court was committed to moving forward and embracing a lot of the changes that we ultimately agreed to. One of the things that we did as well before we penned the agreement was we engaged the community, and that to us was very important. We engaged the local Memphian community, and we engaged the national juvenile practitioner community and juvenile academic community. And we basically had a roundtable discussion. Well, before we did that, we had some meetings in Memphis, and some of them were uncomfortable for people. I know there were some shouting matches and some really uncomfortable things said. And then we went back to DC, kind of thought about some of the comments that people made. One of the big comments that was clear was that members of the community wanted the court to be more transparent and wanted to have an independent outside reviewer ensuring that the court was doing what the court said it was doing. And then we went back to DC. We heard that loud and clear, and we had a roundtable discussion in DC where we invited a bunch of academics and advocates and brainiacs who know a lot more about juvenile justice, and you'll hear from some of them today than I do. And so this was important to us to make this a community process, because the court is and should be received as part of this community. Both court actors, within the court and actors outside of the court need to recognize that's an important part of the court's role, in our opinion. So what's changed since our agreement? Well, one of the things that is, there are some serious successes and some serious challenges. We are not done yet. There are a lot of people in this room who are really trying to work hard to make sure that this happens. One of the successes, I think, is that they're now having initial probable cause hearings, which they were not doing on weekends and on holidays. And so a child being brought into juvenile court on a Friday afternoon on a 3-day weekend might not get out until Tuesday afternoon, even though there was no PC supporting that child's detention. Well, that has stopped now, and they are actually holding these hearings. And just to give you some numbers, I'm not going to spill too many numbers because that's boring to people, but this one is very critical to me. In 2012, the court held 193 initial probable cause hearings. So that's 193 kids who would have been held for days when they didn't have to be held for days. And now some of them were detained because there was PC and what have you, and there was no reason to. The court felt they shouldn't be released. But a lot of those children were able to present their cases, have their attorneys present their cases, and be heard, as opposed to being held and lingering over the course of days in the facility. And then in 2013, over 200 children experienced this as well. And, I think that's a real sign of the juvenile court becoming an active and a court that embraces due process rights. More children are now being diverted from detention because the court has engaged in an objective decision-making tool to assess whether or not a child is really a child that's appropriate for detention. So now there are hundreds of kids who are not being detained but because they just don't belong there. So to me, that's a huge success. And speaking of a huge success, Mr. Bush has a lot of work to do, but he has started, your public defender, and he's building a juvenile defender program from the ground up. And to us, this is a critical component of the agreement because a child really cannot fend for themselves. A child needs a zealous and independent advocate in order to face what's going on in the juvenile court, to understand it, to defend themselves, to present alternatives to detention that the court might not know. And so the legal defense component of this is really critical. And as Mr. Bush has been reaching out to people across the country and locally, the notion of juvenile defender practice as a specialized practice has become clear, and I'm really excited to see what he's going to tell us today and see this program be launched. I know a lot of you all are still looking for jobs. It might be a good idea to think about working with the new juvenile defender office because it's exciting work and it's critical to success here. So what are the challenges? Well, the disparity issue is still a huge challenge, the overrepresentation of black children before the court. And the court is trying their best to figure out ways to divert kids, to reduce the amount of kids that are coming to the court. But it's going to take a lot more work, and it's not an easy thing to solve. It's to some degree, it's a societal issue, but the court is going to do what it can to impact that issue as much as possible. And we know that it's a challenge, and we're excited to see some of the solutions that the court come up with. We have suggested solutions, but this is something where one size doesn't fit all, so it's a process. Another major challenge is with respect to the court's approach to transfer hearings. Now, the court is holding transfer hearings to determine whether or not a child is suitable to be transferred up to the adult court, thereby becoming an adult in the eyes of the law and being processed as a criminal defendant instead of a juvenile. But a lot of transfers are still happening. In fact, more transfers are happening than probably should be happening. And so I think that's a challenge. It might be a cultural challenge. It might be a resource challenge. There are a lot of reasons behind it. And it might be an attorney challenge that the court needs to deal with. Many of those children who are being transferred to adult court are just better suited in the juvenile court. One final thing about our agreement, I mentioned a little bit about the transparency component of it, and you will hear from one of the monitors, Sandra Simpkins, who is a due process monitor today, and the monitors to us are also critical to the success of this, because what they are doing is they're an independent voice with expertise in their areas, who are assessing the court a couple of times a year at the least. Sometimes they're here more, and reporting to the public what is being achieved by the court and what is not being achieved by the court. And it's important for us to have an independent voice do that. DOJ will be dismissed as biased if we're the ones issuing those types of reports, because we have an interest in, some people might think we have an interest in not being independent. That's not the case. But so that's why it's important to have outsiders, people who are not parties. The court can't do it, and we can't do it for the same reasons. So to have independent parties provide that information to the public. Just to wrap up, our hope is that the juvenile courts will fully embrace the principle of due process and equal protection that was articulated in Galt, in Kent, in Roper, all of these wonderful decisions about juvenile rights. And our aim is to ensure that children appearing before the courts are fully respected, that even though to some people it might seem like kiddie court, the liberty interests are really high, and that the courts and the judges, magistrates, and advocates within the court recognize and respect that these children are facing a serious consequence if they are not, and that they need to be treated appropriately and provided with the rights that they're entitled to. Thank you very much. Take care.